Good morning and welcome to our webinar from Public Safety Personnel Retirement System. Today our discussion will be focused on the duties of the local board. As a board member, you might be new to the board or may have some questions, and we'll be sure to get all those questions answered today. Well, today we'd like to talk a little bit about some of the objectives for the day. First of all, an overview of why the local board is needed. You might ask yourself, why is there 256 local boards around the state of Arizona? You might want to know the composition of what the local board is, because it's a little bit different for a city versus a fire district versus a municipality or state agency. We'll be looking at the local board in detail of their duties and responsibilities. We'd also take a closer look at some things to be aware of, and also things to consider, and some additional training tools that we have that are available to you. So with that said, why do you think we have a local board? Why is it established? That's been the lifelong question of public safety, because we need to first of all research and find out, what do the statutes actually say? What does the law say? There are certain reasons for the local board, and the first one is to the administration of the system and the responsibility for making the provisions of the system effective for each employer are vested with the local board. In other words, each agency is set up differently as far as who sits on the local board, and also the decisions that are made locally will affect perhaps your employer rates in the future. All approved agencies shall have a local board, and there's a list of those in the statutes as well. Usually a joiner agreement is signed, and then any member who's contributing will be part of our public safety as a whole group. But each of the decisions are made individually by each employer group or in local board. The pension law under Title 38 sets forth numerous board responsibilities. And when you have that joint agreement signed, you're willing to follow those rules and regulations going forward. So what else does the statute say? In ARS 38 says that you have the power to discharge your duties, and you must request and receive all information from the employer and member for the administration of the system. In other words, locally, you have the opportunity and obligation to make sure all the paperwork is signed for perhaps a new retiree, or somebody may be leaving the drop program, or a new hire, and we'll go through each of those individually. So you have to request and receive all the information, and you are the administrative arm, the local board, making local decisions based off of employees in your area. You're also supposed to distribute the information received from the board and trustees. How many of you have ever received a newsletter from your local board secretary? We usually send those to the local board secretary every other month, and then you have an opportunity to receive those in training materials that come to you as the local board. So we want to make sure you're aware that those are also, we do try to send out periodic information to you as well. Also, we like to furnish the Board of Trustees and the employer annual reports. In other words, you might have the actuary reports that are sent to you, and as a local board, you have the opportunity to receive those, and any budget or any information that we need to be aware of as well. So the statutes are very specific. The law says that there's certain information you need to do as you move forward as a local board. It also mentions that you can request and receive the actuarial evaluations. So every year we post on the website the actuarial evaluations, because each employer group has an individual employer rate, and that's where you get notified of that as you are set up each year. Also, you can receive the financial condition, receipts, and distributions of the fund. Each year we produce a CAFR, or an annual report, that gives us in detail the actual information of where the stocks were invested, what bonds were invested, what real estate. All of that's available on the website as well, a financial update. And as a board, also you have an opportunity to appoint medical boards or doctors to work with you. So with that said, there's quite a few things that the law specifically states of what you need to do for setting up your local board. You may also have the opportunity to determine the questions of service or credited service and amounts. You also have the opportunity to vote on filings for applications for benefits. In other words, our office cannot pay a benefit to anyone unless the local board has approved it and send in the necessary paperwork. So here at Public Safety, we're kind of like a clearinghouse, if you will. We received all the contributions over a 20 or 25 or 32-year period and make the payments, but we cannot make those payments until an actual local board is authorized us to do so. Okay. Also, you can determine the rights of the claimants to the benefits and make sure those votes are on record, and a distribution of payment will be made to the employee who's worked the period of time. You can be sue or be sued based off your duties set forth by the law. But if you always do things with a reasonable range of duties with the prudent man rule, usually a lawsuit doesn't move forward. So, with that said, let's talk a little bit about the composition of a local board. Each board is set up differently in a political subdivision for maybe an Indian tribe or the state agencies or a fire district. And each one of them are set up for a specific reason. Let's look at that composition perhaps first for a subdivision. Perhaps it might be for an Indian tribe or a city. The mayor or chief elected official, as approved by the group, usually the mayor would sit as the chairman of the local board or the highest elected official officer, or he may appoint somebody. So if you're from a city agency or whatever, you'd also have an opportunity to have 2 members are elected by secret ballot. And that secret ballot is set up for each agency to appoint. So there's in other words, they have to be contributing members to sit on the board, and maybe some of you might sit in that category who are here in the office today. There's 2 citizens. One may be part of the merit system and or a designee, but the mayor usually would make those appointments through the city council or through the Indian tribe, whatever it might be. And the 2 appointed citizens can serve on both the police and the fire boards as well. In other words, you can have a joint group if necessary. So as the slide represents, there's 5 members on the board. Usually the mayor would be the chairperson. And if you're in a city in that situation, there'd be 2 elected from the membership, and then 2 appointed representing the employer from the employer side, usually representing the mayor's office or somebody from the merit system. Does that make sense? Okay. So let's look at a couple of the other situations that might come up as well. There might be state agencies. For a state agency, it may be a little bit different. 2 members are elected by secret ballot. 3 citizens may be appointed by the governor, and each state agency would then select the chairman of that local board. Now, here in the office today, we have the city of Tempe, I believe, and Parks and Recreation, so you'd be in that state agency group. And so your chairman should be elected from the membership off those 3 that are appointed by the governor. Okay? So what I wanted to kind of show you that there's 2 different groups that we've talked about so far, the state agencies and usually the cities or that group. Let's go ahead and move now to the fire districts, because this is done just a little bit different. Okay? For each fire district that's organized in 38804, the secretary-treasurer serves as the chairperson. And it's interesting, then 2 members are elected by secret ballot, just like the other ones we just discussed. And then 2 citizens are appointed by the secretary-treasurer, of whom the residents of the fire district and would help serve on that board. So you can see that there's a number of different ways a board may be set up in the public safety system. If you're a fire district, it's one way. If you're a state agency, it's a different way. And if you're in a city or town, it's done a different way. So each board is set up so it can locally, effectively run the business and, for your particular group. Now, what I'd like to do is talk about a little bit about how long they're supposed to serve in that term and about the oath of office. Now, everybody here today, I believe, may be a part of a local board. And you might say, am I in this for life or just for a period of time? Well, sometimes it depends on what your governing board wants you to do. The term of office, as we know, upon taking within the system, there should always be a rule that are set forth. One of the elected or appointed members may serve for a 2-year period, and one might serve for a 4-year period. That's essentially what this slide is saying. So that way there's never a vacancy within the board, so they don't all leave on February 12th, 2014. In other words, they should have staggering dates for their dates of leaving the board. So maybe the employer appointee would leave in 2016 and the other person would leave in 2018. In other words, you stagger them every 2 to 4 years. Does that make sense? Okay. So with that said, we do have some boards, and we just want to remind them that not everybody can leave on the same date. That's why the law is set forth that way. Now, the oath of office, how many of you have actually had the oath of office within 10 days after being asked to serve on the board, just by a show of hand? Everybody here had an oath of office given to you, administered to you? Okay, that's a good sign. Otherwise, you're kind of in trouble. No, you're not in trouble. That's just what the law says, because if the member shall act diligently and honestly in the affairs of what you're supposed to be doing, and not knowingly violate or willing to violate any of the laws, and you're following the prudent man rule, you're not going to get sued. That's why you take the oath of office. It's just a protection for you and for your board. So be sure to make sure you've had that oath of office for any new members on your board going forward. So now that we've kind of got the board established, we know how long the board's supposed to serve for a period of time, usually a 2 or 4 year period. Let's go ahead and jump into some of the board powers and responsibilities. Doesn't that sound like a great word? You have great powers, don't you? All right. Some of the powers and responsibility, as we'd mentioned before, you do decide on all credits of service and disability or service matters, and determine any time any payment given to the system. That's not the number one duty. In other words, you have to decide, does that person qualify after working a 20 or 25 year period for a benefit? Now, we can't determine that here in the office. You have to make that decision on the local board side. You're also asked to prescribe the procedures any claimants that are filed for a benefit. Perhaps you might have somebody walk in the door and say, hey, I would like to have a disability retirement, or I didn't work my 20 or 25 years, but I want to get out early. And you have to make that determination if he can or cannot based off of a certain set of circumstances that he might have. Or you might say no to the disability, but we'll talk a little bit more about that in just a minute. But I want to make sure you understand, you have to make that determination based off of medical evidence or whatever the situation might be in your case. You have to determine the rights of any claimant to a benefit, and perhaps we've reviewed your local board decision. There may be a rehearing based off the original determination. Has anybody in here had that happen to you before, where Public Safety's reviewed your documents and said, we don't agree with what you have to say as a local board because we, by law, have to kind of oversee this, if you see what I'm saying? That's happened to many local boards just because they maybe didn't make the decision based off medical evidence, or the dates didn't work out as far as when he applied and when he actually got hurt or something like that. But if you kind of follow the rules, it's pretty straightforward as far as how you'd make or grant a particular retirement benefit. So with that said, let's look at some of the other powers you might have and responsibilities. You can request and receive from the employer or from all members such information that you need to administer or take actions, even from the information that's sent to you from the Board of Trustees. So the Board of Trustees we're referring to here is Public Safety Personnel Retirement System. We have a very lengthy process in reviewing disability applications now, so we have to notify you if we see something that doesn't look right or doesn't fit with the way the law reads now. Also, you have the opportunity to distribute such matters as local board is determined, especially information explaining to the system received from the Board of Trustees. A lot of times we get requests from different boards to come out and speak to their group. Well, actually, that's your responsibility as a board member to make a presentation on maybe what their benefits might be, those types of things as a board member. So you can always talk to your human resource group, and as a board member, you can use our PowerPoint presentations, all the stuff we've developed, and just explain to your membership, your benefit will be this if you do this, that type of thing. So that is a responsibility set forth in the law. And we have a lot of tools, and we'll talk about those tools in a minute to help you with your responsibilities as a board member. We're also supposed to furnish the employer, the Board of Trustees, legislature upon request, any annual reports to make sure they are reasonable and appropriate. As we've mentioned before, the actuarial evaluation is a big thing that you're supposed to meet as a board twice a year. And one of those you have to meet to at least accept and review the actuarial report. Now, you might ask yourself, what is that actuarial report that he's referring to? It goes through all of the active members that you have in the system, all the retired members you have in your system, and comes up with what your percentage or your cost is going to be to continue to fund those retirees. So there's an employer cost that comes up with that, a percentage of payroll that you need to send to public safety every time you have a payroll deduction. So I just want to make sure that's clear to you, that an actuarial evaluation is something important to look at. Each employer group has a different employer rate based off the number of retirees they have, and that report explains all of that. Okay? I just want to make sure we have that straight in everybody's mind. Also, to receive the financial conditions and the receipts and distributions from the fund. I know it's probably not the best thing to read, but it's a good thing to review the entire annual report every year, because that tells you exactly how we were able to get an 11% return for that year. It tells you exactly where the money's going towards, how many benefits are being paid. So it's just good as a board member, you'd want to be up and understanding why the flow of the money is going where it's going as far as the investment side. So with that said, those are a lot of powers and responsibilities of the board that we've reviewed so far. Let's take another look for just a minute now and talk about to appoint a medical board. That's very specific in the law, where you can actually have a doctor who helps you identify any maybe pre-existing conditions before somebody may start with the system. Now, when we say a board, we don't mean a board of doctors. We mean a doctor that you feel that you can trust and do a fair evaluation to identify a pre-existing condition. If you start appointing many doctors, you're going to get many decisions, if you see what I'm saying. You want to stick with one that you feel comfortable with. Also, to evaluate the member's eligibility for an accidental disability. And we briefly talked about that. That's the number one concern of most of the boards that we've found. How do you process this? How do we make the determination? In fact, on our YouTube website, we have a whole presentation that goes through that whole process, and it takes about an hour to go through. And I'd encourage you to perhaps watch that if you're not sure how to do the processing of a disability retirement and how you'd make that determination. So that's another great training tool that we have available. As we'd mentioned, you can be sued or be sued, and that's very specific in the law on 38-847. But the protection you have if the individual make sure you indemnify yourself from the employer's account, and the fund finds all liabilities arising for any act or failure to act, and you've made it in a good faith, then you will be protected by the decisions that you make. That's basically, you just have to remember, don't look out for self-interest, don't look out for the employer's side, don't look out for the employee's side. Just act in good faith based off the decisions you have in front of you, or maybe it's the medical evidence or whatever you have. If you make it off of that, you'll never probably get in a lawsuit situation. The only time a lawsuit comes up is when people don't do those things and they become too personal in the decision they're trying to make, helping a guy or not helping a guy through the retirement process. A board shall also from time to time adopt various rules that are consistent for your board. All these rules and decisions should be uniform and consistently applied to all members. So we had a little discussion before we started about return to work. In other words, you have to have these rules set up so every employee understands this is what the law says and this is what you can do and what you can't do. Each local board is entitled to one vote as a board member, and a majority is necessary for a decision to be reached. If there's 3 members recorded present in the meeting, do all 3 members have to say yes? Or what do you do in that situation? A majority would be 2 out of the 3. It's always nice, especially on a disability retirement or one that may be questionable, to have 5 board members there, and hopefully the majority would be voting yes or no, depending on the medical evidence. Another power and responsibility, you will have an opportunity to make decisions, or approve or deny every action on your agenda items. It's interesting that we've had a lot of situations where we've read some board minutes and looked at their particular agenda items, and it was never agendized, so how can you take action on it? In other words, you just have to table that and then have it come up for the next board meeting. Okay? If 3 board members are there, 2 are there, we talked about, 2 of those can be in favor of the vote, or vote down whatever the decision needs to be made. So these are pretty straightforward, examples that are coming out of the law, and we just want to make sure you can review those in 38-847 if you need to at any time for the local board. Let's go ahead into some other details. And as we talked about the various rules that are applied for each individual employer group, it's called the Model Uniform Rules. Talk a little about the hearings and the rehearing process for a local board. Model Uniform Rules is set up where you can adopt a procedure required to follow the same rules. So anybody who looks at the claims, if an independent auditor looked at it, you can say, yes, they're following these set of rules. Now, those are actually set up in 38-847F. And we do have on our website a set of rules that are kind of adopted for all of the individuals, for all the agencies. But if you need to tailor them for your specific needs for your board, you can do that in your meetings. Okay, so hopefully you understand what I'm talking about, but we'll show you on the website that we have those posted, and they have been reviewed by the attorneys, but those are the ones you need to adopt if you don't have any set of rules that you're following right now. How about a hearing? This is always a tricky part. A hearing is before a board matter, but if you end up going to the Supreme Court, it's not subject to a rehearing by the board. In other words, usually when this happens, you can see what it's been escalated and decisions made, and you don't particularly like it, and it goes towards the Superior Court. Once they make the decision, it's final. You don't get to rehear it. We've had a couple of those happen where they went in favor of the member because the boards weren't prudent in all the things that they were doing. Okay? The court will send the orders back, very clear distinction of what happens, and maybe give somebody a pension. So we just wanted to point this out, that as long as you're doing the calculations based off of your payroll records, the Board of Trustee, everyone should work in connection to make sure you don't really need to have a rehearing. If you followed all the paperwork and reviewed it prior to sending it in, you're pretty sure that it's okay, then we probably won't ask for a rehearing either. But a rehearing may occur if an action by a majority of the vote of the members of the local board is inconsistent with the information that might be given to us. And the number one reason is we have to look at the medical evidence and review it as just kind of not as a big brother, but just as a policy and the way the law reads, and say, how did that person grant, or how did this local board grant that person a disability retirement when there's no medical evidence that supports it? I mean, there's sometimes we read it and we say, we don't understand how that happened. Okay? So we'd ask for a rehearing, and a claimant of the board may ask for that, and usually it's within 60 days you'd be notified of that information, and then you'd have to have a rehearing to say, well, this is why we made the decision. But anytime you do a disability retirement, there's actually a checklist that you can go through as a local board, and the secretary has to answer questions yes and no, and based off of that information, we can key off and make a decision and see if we agree or disagree with what's happened for the board. Oftentimes, the claimant may receive the notification from the board. It does need to go by certified mail. So when you actually have an action and you approve or deny something, the local board secretary should send the claimant the decision, so it's in writing and sent by certified mail. But if you don't agree with what the action is, or the member doesn't, he can ask for a rehearing, or the Board of Trustees or our office could ask for a rehearing. That's essentially what that's asking for. So if you make your decision, again, based off of what? Medical evidence, there probably isn't going to be a rehearing. It's the member's responsibility if he asks for a rehearing, or if we do, to provide all the necessary information. But it's up to the local board to notify the member of any actions that are taken, again, by certified mail. And the 60-day limit will begin, again, if there needs to have a rehearing happen. So, again, there's kind of deadlines and setup, so this can't draw on forever. The law used to not be like this. I want to make sure you know that. It used to be it just happens, and then they would draw out for a year. But now a decision usually is made within a 3 to 6 month period now. Any questions about rehearings? Has anybody had a problem with the rehearing or anything at this point? Go ahead. If a member is denied a medical disability, maybe it might be an accidental or ordinary disability, the 60 days starts as soon as you send him the letter, certified mail. But as a board, you would have to then address the issue and say, is there additional medical evidence that you're bringing forward? Because based off of what we have, there's nothing here that we'd want to change our mind. But we can still have the rehearing. And usually the member will come up with additional information, and it's his responsibility to provide that for you to make a different decision if you needed to. By law, now we review every application that comes through. Good question. Well, let's take a minute and talk a little bit about your agendas. Now that you're established, you know how long you're going to serve as a board member. The agendas are a kind of interesting thing, because unless it's posted on the agenda, it can't be discussed within a meeting. We have, as we mentioned before, we review all the minutes that come into the office. Every motion is taken. Our retired members group looks and says, oh, yes, this guy made application, and here's on the board meeting. Every person's reviewed, because we cannot now, by the law, make a payment unless the board meets and makes that approval. Okay? That's why there's deadlines for all of this. So let's look at some of the agenda content now. If you have a new member in the system, there are certain things that you'll need to do. You make a list of names taking the medical exams. You list those with a pre-existing condition, and you list the names not taking the exam. Now let's talk about that for just a minute. If a person gets hired on and chooses number 3, and he does not take the exam, he cannot apply for that disability for that particular injury later on. Now, on your agenda, do you actually put Joe or Don or whoever it might be and list the pre-existing condition, he had a knee injury? No, you don't put all that on the agenda, and you don't put that on the minutes of the meeting. You just have to say it's a pre-existing condition, and therefore it's in the minutes that you voted that you've accepted him with that pre-existing condition. Otherwise, you just take everybody else and just list their name and approve them into your system. Now, this has become a hot topic over the years, because it protects you as an employer for what? Any disability applications in the future if you've identified the pre-existing condition when he comes on as a new member. Okay? In other words, he can't apply for that knee injury in 5 years from now if it's already been identified in the minutes of the meeting. That's why for HIPAA laws, you can't make it public, but you can definitely just put his name and pre-existing, and whoever's preparing the agenda, perhaps the local board secretary, would simply state, this guy has a pre-existing condition. You vote him in that way. Okay? Very seldom would you say they would deny the person employment based off of that, but they've notated that they cannot apply for it later for a disability. Because you get into some other laws that says you can't preclude somebody from getting hired, but as long as you know about it going into it, you protected yourself as an employer. You have to notify the member by letter, certified mail, and the local board secretary should always send a letter stating that, yes, you've been accepted, but we know about this pre-existing condition. Perhaps on your agenda you might have disability applications. You might have something along the lines of an accidental disability where it's job-related. It might be an ordinary disability where the guy is non-job related. But those have to be on the agenda prior to ever discussing them or moving forward. Now let's talk just a minute about a disability application. If you know somebody who was injured on the job and there was an incident date and he's making an application, maybe he worked for you for 10 or 15 years, is he entitled to that disability? Perhaps so, but you don't know the answer to that until you have an independent medical exam and go through the medical evidence as a local board and make that determination going forward. So it's very specific steps that you would need to take for somebody who's applying for a disability application. Perhaps there's death of a member. That's always an interesting one. Perhaps he's still on the job or maybe he's retired. All of that should be on your agenda. You should know what's happening within your local organization or from your employer's side. If they've retired from you, perhaps there's a survivor benefit that's entitled to. So you'd want to always notate in the minutes of the meeting if somebody were to pass away or if he's still on the job, killed on the line of duty. One we see a lot of on the agendas is normal service applications where a guy has worked his 20 years and wants out or 25 years wants out. Any drop applications, all of that should be on the agenda so our office knows that you've met, you've verified his employment, you've calculated his benefit. Number one reason to meet is make sure those normal retirements go through. Perhaps it might be an annual review of members that maybe are disabled who may come back to work. You have the right to at least check up on them occasionally, but a lot of times boards just say, oh, he's retired, let's, on a disability, let's just let him go, kind of thing. Because there are some boards that like to have him come back for a periodic exam to see if he could go back to work. Survivor benefits, those are the most difficult calls our retired members group gets, maybe a spouse, or eligible children, or guardian. In other words, somebody has passed away. Our office would then notify you of that if we get the call. Hopefully your office would notify us if you hear about it, because a survivor benefit is always a tender thing when somebody passes away, so that should be on your agenda. So you can kind of see from the flow of this, if there's any time money is stopped or started for payments, it should be on your agenda. Now, this is something people a lot of the local boards don't understand, even for refunds. If the person quits or gets fired, you should have on the minutes of your agenda that person is terminated and is eligible maybe for a refund, or maybe he's transferred and gone somewhere else. That way your minutes document everything. So again, if money's involved, we need to know from the minutes of your meeting what's happened on your agenda and that a vote has been taken. Now, do you vote that the guy terminated himself? No. You're just making a note in your minutes and accepting the fact that you're aware that person is terminated. You don't have to go into the reason. You don't have to go into anything, just that he's gone. Stop his, why his contribution stopped. So anytime money's stopped or moved forward or a payment needs to be made, it should be on the agenda. Okay? And then an annual review of the information sent by public safety. Now, we had a little survey earlier about how many of you have actually received the newsletters that we sent from our office. Okay, we send them to the local board secretary, and they should be sending those forward to the board members, because that always has valuable information to help you through your process meeting as a local board all the time. And they are all posted, the newsletters, on the website, and we'll show you that in just a minute. What else should be on the agenda? Perhaps any expenses of the board other than the budgeted items. There might be training conferences like you're coming to today, attorney costs, independent doctors, medical exams by doctors, anytime you have a pre-hire or a re-exam, rehearings, service purchases, military time. Our office notifies you of that. If they've purchased the time, you should get a letter. That should be on the agenda. Any drop applications that you're processing because it starts somebody's money or you're paying some monies out. So there's a lot of things to put on your agenda. There's a lot of reasons to meet. But by law, you have to meet twice a year, as we'd mentioned, and some boards meet every month, some meet quarterly, and some meet, every 6 months, depending on how much they have going on. So now that we are aware of what else needs to be on the agenda, you might have a future agenda item that you want to discuss. You might have a report on the elections, on maybe you as a board member got elected. That should be in the minutes of the meeting and ratified. Approval of any previous minutes, new business, or call to public, and then you close the session. Now, the local board secretary is usually tasked to, produce these minutes later on and send to our office. But it's interesting that by law now, after you had a meeting, you're supposed to send at least the draft minutes in within 20 days, certified mail. Okay? Because that notifies our office of any actions that you've taken. Because you might not meet for another 3 months or every quarter or something, but at least our office is aware of what's going on generally within your organization. Any questions so far? We had this presentation once to a small group, and they says, well, we don't have enough agenda items to go over. And we go, well, now you do. They didn't know they were supposed to do all of this. So it's just so you keep in mind that if you do nothing but maybe review a newsletter article or something that we wrote, or there's webinars that we provided in the last year that you could review as a board. There's a lot of reasons to meet for training if you don't have any action items that you need to take right away. Let's spend a few minutes talking about one of the most difficult subjects, and that's the disability applications and the pre-existing conditions. We've touched on it earlier, but we want to go into a little more detail about that topic. If you have a pre-existing condition for somebody who's hired after October 1st, 1992, you have to notate that and put it in the record of the minutes and notify the members we talked about, and make sure there's no question that that person cannot apply for disability later on, even if it's a knee injury, a toe injury, a back injury, or anything like that. The board staff reviews those pre-existing conditions. Yeah, of course, you can't always talk about these in general discussion in the meeting, but if you need to go into executive session, it's okay to put that on the agenda. You may go into executive session for that reason, to talk about it, to make sure not violating any HIPAA laws, but just so maybe board members might ask the question of why, or whatever the situation might be. Okay? So as you've reviewed those, you just need to be aware that it should be on record, and the member is aware of it as well. A lot of times the question comes up, are we really protecting the plan from non-qualifying disability applications? Absolutely. We had a group that I went to see not too long ago, and we realized that they'd never had pre-existing conditions in the minutes of their meeting. They never accepted all their new membership, and they'd been in the system for 3 years. So what presents the problem? Any one of those individuals could have applied for disability for any of those pre-existing conditions, and you just open the checkbook of the employer because of that. Okay? So it's always good to have it on record right up front. It helps protect the member and making sure he can't qualify for that disability going forward. It might be a dislocated knee, a back problem, even asthma could be a situation. Especially if he's a firefighter, it might affect his job going forward. You may want to get your doctor to find all pre-existing conditions and give him questionnaires of what types of things you're looking for. The employers that are very diligent on this have their own pre-set up questions that they're asking the doctor to make sure they've checked off and asked those questions when the guy comes in. Your board should meet to approve these receipts of the doctors on all new hires as well. So, again, it protects the plan, your plan. The employer contribution rates would rise if you have an excessive amount of disabilities. In other words, you're paying for somebody because he didn't work the 20 years. Another reason an employer may have asthma, you may want to document it. If that condition gets so bad, he may not be able to perform his functions. That's a good example. It's a fine line, but it's a good example. If the condition was pre-existing to their employment, they may not qualify for retirement. We don't know unless you have it documented all the way through. If the doctor finds a condition, it's always nice to have them put it in writing. So it's not, I heard, but the doctor said in writing, this is why. Okay? And there is some good news if you haven't been doing this, like this group that had never done it. Yeah, let's go ahead and get started. Maybe you can just identify those that you can right now and get started if you haven't been doing this. The employer does have to pay for the exams if necessary. Some use AZ post exams. Some have separate medical exams that are done. So there's just different ways to make sure you've covered all the bases. But the employer does have to pay for the cost of that, depending on what your rules and regulations say for each employer. You don't have to actually see all of the information from the results of those exams as board members, but it's nice to have a summary that somebody could provide so you're aware of it if it needs to be talked about in executive session. Does that make sense? Let's go ahead and talk a little bit about the medical board. Can be comprised of usually one doctor or a panel of doctors. Their sole purpose is to help protect you and the plan from pre-existing conditions or help you with any disability applications. Now, normally you don't use the same doctor in a pre-existing condition and then send him back to the same doctor for a disability. You want to find a specialist for his particular area. A lot of questions come up. Is the employer required to take the exam? The answer to that is no. Personally, he could not take the exam. But if he fails to take the exam, he waives his rights to that type of disability going forward. And we've had some that do that because they said, hey, I'm not taking that exam. I know I've got a bad back. Well, you just forfeited your right. All the employers do require some type of exams. We talked about the AZ post sometimes works. It's probably best to have in your board meetings a certain guidelines if you're going to have 2 exams or depending on how you want, what your employer is willing to pay for. Any questions about pre-existing conditions? Are we doing that at your place? Go ahead. Is it required to have 2 exams? Typically, most employers are going that direction now because the law provides for you to do that. Again, some use the AZ post, some use their own medical. But it's just as long as you've covered your basis is what the question boils down to. If you feel like the one exam is sufficient, that's your employer decision. But the law does now provide that you can do both if necessary, if you need another opinion before starting that guy. If anything's in question from the AZ post exam, definitely send him to another exam to clarify. Yeah, I think it's interesting because if I was an employer, I'd want all of them to take 2 exams because maybe one doctor doesn't always see it, but there's costs involved and not all employers are willing to bear that cost. But if they don't, they could apply for that disability if it's not notated somewhere in their record. Good question. Thank you. So some things to consider going forward as a board about your meeting notices, perhaps your agendas, your executive sessions. Let's go ahead and discuss some of these real quickly. Your meeting notices must be done 24 hours in advance. That's just the law. They have to be posted. That's part of open meeting law, and all the rules apply to public meetings as they do in your board meetings. In other words, you can't just skirt the issue and have 3 board members get together without posting that on an agenda. Some type of notice. The agendas need to be very clear. If you forgot to put something on the agenda, you can discuss it under new business, but don't take any action on it. If you need to go into executive session, you must have that posted on your agenda. It's always good to post it there on your agenda because in case you need to go into it, especially on a disability. If there's something that affects a member, you should notify him. How often do you go into executive session? We always recommend not to do it without an attorney. Your attorney may know what you can and cannot discuss. You need to somewhat record it. And also, there is a fine if you're talking about things you shouldn't be in executive session as well. The Attorney General could fine you $500. I'll give you an example on this one. There was a local board that recorded the minutes of their meeting, and it got to the hearing, the rehearing, went to the Superior Court. And guess what the judge asked for? He only wanted one thing. He said, I want the tape of what the executive session meeting was, and I'll make my decision off of that. You're just covering yourself, because he's not going to go through the hearsay of everything else. He wants to know exactly what was said in executive session. So be careful sometimes what you say in executive session. Okay? But it's good to have it available, because that's what he had to make his decision on. The minutes... you need to record the minutes very briefly typed, not verbatim. You need to send it, as we mentioned, within 20 days. The local board should take the minutes during the executive session, but we don't actually need to see them, but it should be somewhat detailed so they know why. But you'd keep those on file. We had a group the other day that sent in their executive session minutes, and we said, no, we can't read those. Those are, executive session. We cannot read the privileged information, okay? But it's good for the boards to have those on file in case they're ever needed for a Superior Court rehearing type of thing. Open meeting laws protect anyone else from reading those. So they're your minutes. They're for you to discuss, and then we record all of our minutes, but we don't make them public to anybody. Okay? And there's some interesting things said in there sometimes, huh? So be careful. All right, so the board minutes should be signed by the board chairman and then sent to our office, certified mail within 20 days. Question? Those minutes should always be approved at the very next board meeting, right on the agenda. That should be a standard practice. And then the final minutes should be sent in as well. So you're sending in the board minutes for the draft copy, then the board minutes from the final copy, the ones you voted on to approve them. Minutes for disabilities. If you grant a disability and you need to send those in immediately, as we talked about the draft, sending in letters, and all that needs to be sent in, obviously, all minutes should now, by law, be sent by certified mail. Now, what does that do for you? It starts the ticker from any rehearing starting, the 60 days, all the things that we've talked about up to this point. But we cannot even come close to approving or doing a disability unless you've gone through the process of receiving the application. And the minutes you're meeting, you should make note that, we've reviewed his application. Yes, we're moving on to an independent medical exam. Then he comes back with additional information. Then you have to meet again as a board and say, we grant this or deny it based off the medical exam. So it's kind of a process that you go through on a disability. But if you send it in certified mail, you're always safe going that forward. That's what the law says now. Now, the local board staff, is there any local board secretaries here today? You get to do all the work, don't you? Usually the local board secretary takes the minutes of the meeting, processes all the applications, the agendas, the board, meets the needs of the board. Board members can do this sometimes, but it's not always recommended, depending on how large the agency is. Some of the larger agencies have separate secretaries of different boards. It may be somebody from Human Resources. It depends on how it works for your organization. Now, let's talk about local boards using legal counsel. If you don't have much on the agenda, you may not need a particular attorney at that board meeting. But don't be a penny pincher. If you have a disability on the agenda, you may want to have your attorney there. Okay? So if you have just a straight retirement in 20 years and the guy retires, do you need an attorney there? Probably not. That's what we're saying. But if you have something that might be a little dicey and you're not sure how to handle it, attorneys can usually guide you through the process and keep you out of the legal system. If you can always call our office and ask for various individuals here to help you out on any advice. Other boards like Phoenix has been very helpful. They always seem to have they've seen everything, if you know what I'm saying, because they've got 2,000 plus, active members. For board questions, you can talk to somebody who's done it before. Like, do you know who your boards are in your area? Who your sister boards are? Maybe you could ask them the question. Maybe they've been through it before. Same with Tempe. Tempe's runs things fairly smoothly right now, so they'd be a good one to ask as well. Your sister boards are always good to ask about crazy things sometimes. All right, let's go ahead and kind of summarize here for just a minute. I have a few things I'd like to show you. If you look at the statutes of the law, the local board shall adopt bylaws, and we're going to look at some of those specific bylaws. The secretary, elect a secretary whom the board will then, use and help run the meetings. The secretary of the local board should keep the records and send all minutes within 20 days and forward all communication to the board of trustees. We've kind of discussed that already. It's a big job, isn't it? Some weeks it takes a lot of time, some weeks it's not as busy. The law also states specifically the fees of the medical board and the local legal counsel and all expenses shall be paid by the local board, the employer. It needs to be part of your budget. We had somebody send in their bills for an IME that they had, and they says, well, you can't pay that. I have no funds to do it with. It has to come from the employer budget. The local board shall issue directions to the Board of Trustee concerning all benefits pursuant to the account, because it affects your funds, it affects your contribution rates, it affects a lot of things. That's why it's done on a local board side. Local board should keep on file all the matters, any information from the Board of Trustees, especially your actuaries, for a few years. You should have those on file. So if anyone's ever come out and audit your group, you'd be able to say, we're compliant because here's our oath of office we've taken, here's our minutes of our meeting, here's our actuary reports. You could have a file for just an auditor to ever see anything like that. All right, a couple things that we've provided here from Public Safety is some resources to help you do a better job and be more effective. We'd like to talk a little bit about the summary of the statutes, the tools and resources, and the PSPRS staff and the contacts we have available. So let's go ahead and take a look at the statutes. Are all located in 38847 for a local board. So if you were to click on this particular link that we're going to send you, it would take you directly to the website. So you can be well assured that all the laws are out there and you can see them, and if you click on that link, you can review them, all the things we've talked about today. One of the tools and resources that we've developed is the local board training. We do have on our website frequently asked questions. We have our scheduled training like we have today, our local board newsletters, and videos of past trainings. Can we maybe click on the local board training website so they can become familiar with it? Okay, so it brings up public safety. You've all been to this website before, perhaps? So on this website, we do have now the Members Handbook, and we'll discuss that also. If you see the Public Safety Members Handbook, a lot of members were requesting, what are my benefits? And as a local board member, you should be able to explain those benefits, and this handbook can definitely, if you read through it, can explain everything they need to know, especially at benefit fairs or anything like that. We found that to be the most useful use for that tool. Model rules for local boards. If you click on the public safety link there, you'd be able to see all the rules that we just talked about. And each board would be able to look at those, okay? So let's go back for a minute. It kind of goes through definitions and everything for all of the different groups. Let's click on the Members Handbook for just a minute while we're here. If you go through the Members Handbook, you'll see a table of contents. Maybe a person is planning for retirement, Section 4, for example. But you can see all the different sections. It gives you, maybe you need to choose a retirement date. And then it kind of gives you a list of all the things that you need to do to get ready to retire. Now, is this valuable or not? This is definitely one of the tools that we created late last year that's been most helpful for our local board members to explain what the benefits are and how they go about the process of obtaining those. Okay? So hopefully you're using that and sending that to all your board all of your membership if you have their email address as a link to this. Okay, let's go back to our website for a second. Frequently asked questions we've talked about. If you click on that, it goes through all the return to work rules, all the different frequently asked questions that our office has received, and we've got covered just about every situation. The webinars, as you can see, we have a financial update. We've got PSPRS members' duties of local board like the one we're talking about today. As you can see, if you want to learn about disability paperwork, if you go down to the very bottom one, you can see return to work rules or open meeting laws. So we've had quite a few webinars that have explained all this, and it's good for you to, as board members, review those at your own time or in a board meeting if you put it on the agenda. If you haven't been through the disability paperwork one, that's the first one I would go to. We found more board members said that's probably the best tool we've got how to process a disability. Okay, let's go back for a second. And as you can see, the Retirement Instruction Manual is the one down towards the bottom. If you click on that, this was designed for you to help a member through the process of retirement. So between this and the disability PowerPoint we just looked at, you should be able to do just about everything you need to do. And again, if you want to know how to navigate through the spreadsheets or look at the retirement package, qualifications for normal retirement, you can click on any one of those buttons and it'll take you directly to that location. Now, the local board secretary said this is the best thing that we've ever done because it steps you step by step of what needs to happen. So let's go back to our presentation now that you kind of know what's on our local board training website. Hopefully some tools that you haven't been aware of before that you'd want to review as a board member. And again, the videos of the past training has probably been one of the more valuables, especially if you're new to a board. You'd want to just kind of click through each one of those and listen to hear what we've said in the past. It kind of gets you up to speed very quickly. This particular one is, I find, has been very helpful. Recently, we just did a couple weeks ago how to help your local board secretary out. But if you just click on one of those, it just goes directly to the actual presentation material. We've talked a little bit about the tools for the retirement manual. There's one up there, as we showed you, for prior to January 1st, 2012, and somebody that's hired after. If you look at the spreadsheets, retirement spreadsheets, they help you through the process of processing retirement and gives you all the paperwork that's necessary for a particular retiree. But on this particular input sheet, you can see it's okay for you as a board member to kind of fill out your information and see how it fills out down at the bottom. These tabs at the bottom, the static information, and it helps you print the forms that are needed for the retirement. Okay, so there's about every tool necessary out there for the board secretaries to hopefully do their job. Now, do you need to know how to do that as a board member? Probably not, but it doesn't hurt for you to see the process, and that's what we wanted to talk about today. So let's go back to our presentation material. Resources for your members. We talked about the members handbook, and we'd like to now discuss a little bit about the members only website. Because in the members only website, if you log in and you can actually pinpoint your retirement date, which is a great tool that we worked with IT to develop so they can kind of see their contribution history. It helps keep the members more informed that way. All the retirees love it now because their 1099s are there immediately after the close of business down here. So there's just a lot of things that are available for the members. So as a board member, number one thing I would do if I were to leave here is have all of my members that I'm working with sign up for a members only website. Very valuable tool. And as we talked about the public safety YouTube page, and we also have a Facebook page that kind of keeps people up to date as well. So these are all the various tools we've tried to develop the last 3 to 6 months to a year. And we found them all very valuable to help the members, especially the board members, know what's going on within the organization here at Public Safety. My name's Don Minear, as we talked about earlier, for those that came in a little bit late. Robert Ortega is also a trainer here, training coordinator, and LaDawn Toger, if you need to get a hold of her for any buybacks, purchases, military services, her group can take care of that. If you run any retirements through it, usually goes through Bonnie Brown from our retired members area. So there's plenty of people here at the office, is what I'm trying to say, to help you. If you have any questions, I'm happy to help, or Robert can help you through an individual question or anything like that. We really pride ourselves on customer service, especially for the board members, because you guys are their front contacts for a lot of the people that do get questions as well. So with that said, we thank you for attending today.